More like this, based on one or two. Today will be August 1st, like this. So don't be small matter. I put for the tribunal lifestyle. So the claim so the matter tear apart not canvas. You both time face cap now. What for you? Normally, before I drop this audio, so I think I'll beg you. Anywhere where they watch this video from, I beg you all they share this video so that anybody will get interest for this tribunal lifestyle. May they for see this video, may they know the sub. I don't always time. I want you go straight enter out this sub for court today. No time. That about DNA. That be great. Today we get one special guest for inside the court. Today now. Yes, now the great Chimamanda Ngozi Adichie. She deal with us when I travel last today now. Yes, now she show face now. Now what for you? I'm going to give her bottle water. She said she deal with cannot rest. That be great. Everybody starts. Now the judge got us say. He said we will begin with the objections before we come to the main written address. A.B. Mahmoud, that's INEC lawyer. Now the guy can start. Say, this case is different from the earlier case because the petitioners here also raised objections. Chief Live Uzoku, which is Labour Party lead counsel, come to say, my lord, we prefer for them to start. I talk about Naidi Mahmoud, which is INEC lawyer, come to say, my late friend Stephen Edehi will lead the procedure. Now Stephen Edehi can stand up, come say, the first respondent, which is INEC, objection on the admissibility of documents in evidence was filed on the 14th of July 2023. We also filed a reply on point of law on the 28th of July 2023. We adopt the content of the said written addresses. Now the judge can say indicates there's an error. Now the Stephen can say we seek leave to correct that line to read which do not have. The judge can say correction done. Now the can continue, which is INEC lawyer. What I say, thank you, my lord. I adopt the same processes as our argument before this honorable court to sustain the objections. Now the judge can say, Chief Olanik Pekun can say, my late brother Yusuf Ali will conduct the next proceedings. From there, now the Yusuf can start. Because the argument on objection of the admissibility of documents was articulated and filed on the 14th of July 2023. Upon receipt of the reply of the petitioners, which is Peter Obi and Labour Party, it became very imperative to file a reply on point of law, which we did on 25th of July 2023. We adopt these processes in urging my noble lords to sustain the objections and strike out the inferred documents before my noble lords. Now, L.O. Fagbemi S.A.N. for INEC. Got to say, we filed our written address in respect of the objections filed on the 14th of July 2023. We also filed a reply on point of law on receipt of the petitioner's reply address dated 27th of July, but filed on the 28th of July. We adopt our argument to reject our discountenance to reject or discountenance those documents. Now, Labour Party lawyer Dr. Live Ikoto say, our Kalu SAN will respond to the processes of the first respondents if it pleases my lord. My lord could say fire down. That be great. Our Kalu could start, which is Labour Party lawyer. Like I said, the petitioners have the two processes in response. The first is the reply to the first respondent, which is INEC. It was filed in the 3rd of July 2023 against the first respondent's objection filed on the 14th of July. I adopt the said processes argument. The petitioner's reply to the objection raised by the second and third respondent was filed on the 20th of July 2023. In respect to the objections of the third respondent, the petitioner's reply was filed on the 23rd of July 2023. We adopt the petitioner's reply to all the respective parties. Now, Dr. Live Koto say, Chief Anechebe SAN will take charge of our own objection. Voila. From them, now be bang. Now Chief Anechebe starts. SAN, don't forget. For Labour Party. I say, may it please my noble lords, the objections against documents tendered by the first respondent, which is INEC, was captured in our written address dated 22nd of July, but filed on the 23rd of July 2023. There was also an objection filed against documents tendered by the second and third respondents, filed on the 20th of July 2023. We respectfully adopt the arguments canvassed in the two processes in opposition to the documents tendered by the first, second, and third objection. There are our submissions in urging your lordship to expunge the said documents from the bundle of documents and sustain our objections thereto. English they cry. That's Stephen Edehi for INEC lawyer. Gonna say, in opposition to the petitioner's objection on the documents, we filed a document on the 20th day of July 2023. We adopt the content of the said written address to overrule the objections. And the court gave the parties 20 minutes each for their oral submission proper on their final written address. There is a timekeeper who rings the bell to indicate once the period allotted to each party is exhausted. You understand me now? The court give each party 20 minutes to talk their own final word on this matter. The timekeeper, once that 20 minutes reach, they ring bell, you stop, quiet your mouth, this and that. From there, I big bay Yusuf Ali for INEC lawyer. Now I start. Because say, in reaction to the petitioner's objection on the documents, we filed a written address filed on the 25th of July 2023. In opposition, we adopt the arguments in the document as our argument, especially as there was no further reply by the petitioners. N.O. Fagbemi SAN for APC. Got say, in respect to this objection, we have no processes filed. And the judge could say, we will now go to the main addresses. Instead of 10 minutes, the parties will be allowed 20 minutes each to address the courts. Wahala. From then I be bang. A.B. Mahmoud SAN. That's INEC lawyer. Nice start. He said the first respondent has filed the final written address dated 14th of July 2023. Along with that, we also filed a list of authority, also dated and filed on the 14th of July 2023. After we received the petitioner's written addresses, we also filed a reply on points of law, filed on the 28th of July 2023. We also filed a list of authorities on the same 28th of July 2023. With respect to these are the processes filed by the first respondent. We adopt same as our arguments in this petition. My lord, for all the detailed arguments canvassed in our written addresses, we humbly submit that this petition is lacking in merit and should be dismissed by the court. I will seek your lordship's indulgence. On page 15 of our written address, we set out the issues of determination. They are listed. I will only speak to two issues. The first is issue number B, has to do with the complaint by the petitioners of non-compliance with the provision of the Electoral Act. The essence of the complaint is with technology introduced by the first respondent. The rationale seems to be appreciated by the petitioners. However, they misunderstood the technologies. The BVAS was used for accreditation and transmitting of results. The IRF portal is a result viewing portal. The evidence shows clearly that the first respondent went to great lengths to ensure that this technology functioned as designed. The applications used on BVAS was developed in-house, tested for performance and vulnerability. The data were also hosted on Amazon Web Services, and evidence shows it was the most advanced and secured web service provider in the world. The intention of the first respondent was to beyond doubt, both by the petitioners and ourselves. The petitioners have contrived in their mind the so-called electronic collation system, which was prescribed by the first respondent, which they have brought to no evidence to show. Although the petitioners consistently argue that the National Assembly and presidential elections went on concurrently, but they never showed there was any electronic collation of results in the National Assembly or any other election. What was in place was the manual collation. The second is in response to the glitch. This glitch was orchestrated by human beings to alter the results. The case put forward by the first respondent is that the glitch didn't occur by human effort, but by the normal function. My submission was that if there was human interference on the machine, the petitioners ought to have showed it. If they failed, that argument also fails. Also, the IRF portal was for public view and did not affect the result collation. It was only for trust. All the witnesses have agreed on this. All the arguments was of AWS being faulty or not results in a no issue. There has been arguments about 18,088 so-called blood polling unit result on IRF. My argument is that this goes to no issue, as those blood results did not in any way suggest that the original copies of the result sheets were also blurred. They have not tendered the original copies, which are in the possession of their agents. That complaint of blood results are simply for dramatization. See finish. From the state of this evidence and from the state of all the pleading before your lordship, which interrupted the transmission for over 4 hours, did not impact the results, and there was no evidence that there was any manipulation of results. Moving to the second point in relation to the 25%, I'll first of all say that there is no dispute as to facts. The only issue is in relation to the interpretation of the relevant aspect of the condition in section 134, which says the candidate must score 25% in 2/3 of the states and the FCT. Your lordships should not adopt an approach that results in an absurdity, which the voters in FCT are ascribed superior position than the other voters. We hereby submit our arguments. Yeah. From there, I Wale or Lanik Pekun for the second and third respondent, because say the second and third respondent filed their final written address on 14th of July 2023. Also on receipt of the process filed by the petitioners, a reply on the 21st of July was filed. We also filed a list of additional authorities on 31st of July 2023. We adopt these processes in urging your lordship to dismiss this petition. We will also argue anon that it is a gross abuse of processes of court. I will draw your lordship's attention to a process filed by the petitioners, that the petitioners have no final written address. The petitioners' argument is in response to the second and third respondent are not acceptable, and will seek my lords to discountenance this document. I will address a few areas. One is about non-compliance, that the results were not uploaded in real time. Upload to IRF is not part of the collation process for the purpose of declaration of result, as all collations are done physically and at the respective polling units and collation centers where results are entered and at the appropriate INEC locations. May I refer your lordship to Exhibit X1, which is a judgment of a superior court given at the instance of the second petitioner, that the court should declare that the INEC should declare results electronically, and judgment was given. The second petitioner, which is Labour Party, also went to a high court in Lagos and obtained a contrary judgment. The Court of Appeals quashed that judgment, stating that the Exhibit X1 quashed that decision. My lords, may we draw your attention to 137 subsection 1D of the Constitution, The issue does not arise at all. It says he is under a sentence of death. It is a present tense. Not that he was, but that he is presently under. I draw your lordship's attention to subsection E, that he is sentence is a period within 10 years. In primary school, we were taught present tense and present participle. The second respondent is not under any fine. The argument in respect of the FCT, let me read the provision of the constitution 134 subsection 2. May I make this submission and unvended needs that the constitution is talking about is votes scored, not landmass, and that was the Supreme Court emphasized in the case of Awolowo versus Shagari. I don't call they make mistake. I don't tire on verse. The second respondent scored more than a quarter of the votes scored and the FCT. The first petitioner, with all respect, has no local standing to question the 25% outcome of this decision, as the constitution forbids him to contest in a re-election if such were to be the case. Lastly, is the question of the first petitioners breaching the law. We tendered Exhibit RA18, gave evidence that he was not a member of the Labour Party. You cannot benefit from your own wrongdoing. There is no connectivity between the petition and the reliefs and the parties. May I urge my noble lord to dismiss this petition and urge my lordship to do hold on my bended knees. From there, the fourth respondent, time for the which is APC, what could talk their own now. Person who want to speak for APC now, L.O. Fagbemi S.A.N. Time could start. Because the fourth petition filed a written address dated and filed on the 14th day of July 2023. There's also the fourth respondent's reply on points of law, which is dated the 27th day, filed on the 28th day of July 2023. Respectfully, I adopt and rely on these two processes. I urge the court to dismiss this petition. I will adopt the oral submission of my A.B. Mahmoud and our leader, Chief Wole Olanipekun S.A.N. I have refrained myself, but I have to be mild to say that this petition is ambitious. The second petitioner has abused processes. They suffered defeat in Abuja and ran to Lagos. They had a short victory as the court appealed. The Court of Appeal shows the results were disastrous. Unless there is an appeal to overturn the decision of that court, this procedure here is a gross abuse of process. The investigation in an election is to see whether voting took place, the result declared, and collation was done. I will give it to them where they have done well, and that's that they did not dispute that voting, counting, collation, and results are the important things. The one thing at the unit level is the most important thing. If anyone wants to attack the result, there has to be a polling unit by polling unit allegation and proof. If they are contending that there were contentions with the transmission, it has to be polling unit by polling unit proof, which was really lacking. It is a question of before you go to IREV, you must start low rev, the much taunted issue of rerun is a two-horse race between the two leading contended votes, which does not concern the petitioners. Section 134 subsection 3 of the Constitution also buttresses this point. Even if you want to do this, your lordship will ask, where was the man who came second? It is one of the reasons why we will describe this as a meddlesome interloper. Yeah. Disqualification means anybody is qualified except he suffered under the provision of section 137 subsection D of the Constitution. It is not a criminal forfeiture. There was no charge, no trial, and no conviction. No exhibit BA. So exhibit BA is devoid of the requirements. PW1 in this regard admitted that strictly speaking, there was no defendant for any criminal offense under cross-examination. In any event, evidence abounds that there was clearance given to the second respondent, a clean bill of health. The question of the status of FCT does not enjoy a special status as far as elections are concerned, especially presidential elections. The second respondent scored more than 25% in about 29 states. That suffices and to do otherwise will amount to constitutional absurdity. On the issue of IREV, there is no point that has not been decided. The case has been settled by the decision of the Supreme Court in SC versus that code. It is reported that Oyetola versus INEC 2023, blah blah blah. This has cleared any doubt in the air as to the position of INEC, whether it adequately conducted the election. No one is perfect, and INEC scored at least 80% in this election. From there, I be bay. Time for the petitioners to talk. Wahala. For the petitioner, now Dr. Livy Uzo starts. I gotta say, in reaction of the address by the first respondent, the petitioners filed their final written address on the 23rd of July 2023. In reaction to the final written address of the second and third, the petitioners on the 20th of July 2023 filed their response. Finally, in reaction to the address of the fourth respondent, the petitioners filed their response on the 23rd of July 2023. We seek to adopt the final address in urging my lord to uphold the petition. We want to submit that the respondents have labored in vain to diminish the importance of IREV, and in the case of Oyetola versus INEC, which fact we cited, stated that IREV is part of the electoral process. I will refer to all the witness depositions of ROW1 because I would like to drag them out of their comfort zone. He said, I know that the authentic and statutory prescribed is the IREV portal. They are trying to downplay that. An election which 18,088 blood results were uploaded to the IREV is a faulty election. There is something remarkable about this matter. INEC issued CTC of purported polling unit results to the petitioners. Out of that number, 8,123 were blood, certified by INEC. Some were blank copies of A4 papers. Also among them, you have pictures certified by INEC. And the judge can say, we are not writing because it is in your written address. How the guy can continue? Because say, how can they say they conducted an election properly? It is my respectful submission that a CTC of any document in a result must be an exact replica of the original. They failed to produce the originals of the copies of the certified because it couldn't be any other than blank sheets. Let me go to the issue of fine or forfeiture, which the second respondent talked about. It is not in doubt that the second respondent forfeited $460,000 as proceeds from narcotics and money laundering. They do not want to hear that. We clearly relied on Section 137, subsection 1D, but they are pushing it to another section, E. You cannot make our case for us. The provision says any court or tribunal. It is very clear. My lords, there is the attempt to claim that the first petitioner is not accommodated under Section 134. The submission that in the case of rerun, there is the argument that the first petitioner will not be accommodated. The only candidate who comes squarely within the provision of the Section 134 subsection 3B is the first petitioner. Even if they created wrong interpretations, it cannot work. The case of Awolowo versus Shagari was cited. Of course, the provisions now of the constitution was not available to interpret that case. Let me quickly refer to what my brother for second and third respondents said. that the petition was abandoned. I couldn't believe this coming from my brother, whom I respected. Shocking. My brothers did not urge you to interpret "and" as being disjunctive. I didn't hear that. I submit with the greatest respect that the petitioners have proved their petition, particularly with the issue of non-compliance. They had no evidence. At one point, they said it was the printing toner that caused the issue. At some point, they said glitch could have caused it, but the alleged glitch lasted only 4 hours. But up to the 29th of May, they were still giving us blurred results of the election. Finally, the petitioners have proved that there was no glitch whatsoever as alleged by the respondents. If I talk about one, nine, the court, they can adjourn the hearing for judgment to a later date. Say the date for the judgment, they go announce them to all the parties. So whenever they announce that date, so they want to pass that final judgment for this matter, so I go still let you know. Normally, I remember your humble boy, Kel Benki. Now Miss Spears, I bring this update for us. So anyway, we just thank God for everything.